Good morning, gentlemen. Thank you for accommodating the court schedule as well.
Good morning, Your Honor.
You each will have 15 minutes, and appellant may reserve up to 5. Thank you.
Thank you very much. May I proceed, Your Honor?
Yes, please.
Thank you. Good morning, Your Honors. My name is Robert Dixon. It's my privilege to appear before this court this morning on behalf of the appellant, Melanie Trivett. I would like to reserve 5 minutes of my time for the purpose of rebuttal. Thank you. Your Honors, briefly, the appellant brings 3 issues before the court this morning, which have all been briefed, and I'm sure the court has carefully considered up to this point. The issue that I'd like to focus on is issue number 1 at this time. That involves whether or not the trial court should have granted the motion to suppress Ms. Trivett's statement that was obtained by police and entered into evidence in the trial of her case. Just briefly, as a factual background, as the court is aware, Ms. Trivett was convicted by jury in the Medina County Common Pleas Court of 1 count of child endangerment, felony of the 3rd degree, and she was sentenced for that offense. Remains under sentence. She does remain under sentence today. This case began with Ms. Trivett's child being taken to the hospital after Ms. Trivett noticed that he was experiencing what they thought were night tremors, or night terrors, I guess they described them. Eventually the child was taken to the hospital, and it was determined by doctors there that the child had ingested Wellbutrin, prescription medication, which was prescribed to Ms. Trivett, as the evidence did show. The child was treated and eventually released, and there was really no dispute that was the case, that the child had suffered from ingestion of that medication. The case was investigated by the Children's Services Bureau in Medina County. They eventually very quickly closed the case. Then, somewhat unusually, a little bit later, the Medina Police Department began an investigation, and in sort of an unusual way. And the way it began was this, and the evidence showed this in the case, that police officers in Medina were called by Bedford Heights Police Department. And Bedford Heights Police Department had been prompted by the soon-to-be estranged parents of Mrs. Trivett's husband, that they, Bedford Heights, should contact Medina and look into this matter. So it was a call or contact from Bedford Heights Police at the prompting of the parents who worked for the Bedford Heights Police Department to investigate this matter. In response to that, 2 Medina police officers, approximately about 2 weeks, I think, after the child had been taken to the hospital, about 2 weeks later, they showed up at Ms. Trivett's home, 2 officers. And at that time, they indicated to her that they were there for the purpose of taking her in for an interrogation. And that was the testimony, that they were there to take her in for an interrogation. They directed her to put on her shoes and her coat. They led her in an to an unmarked police car in perpetrator fashion, with 1 officer in front, 1 officer behind her. They insisted on taking her in their car, even though she said, I can drive to the police department, not a problem. But they insisted on taking her in their car instead of allowing her to drive. They placed her in the back seat in perpetrator fashion, and the doors automatically locked upon her entry into the car. They then took her to the police department, led her to the basement of the police department, where there's an interrogation room. In that room, they said, we're here again for the purpose of taking your statement. She inquired, could I please take that home, and I'll fill it out there? And the police answered, no. They said, no, we prefer you do it here. That statement took approximately 2 hours to complete the entire process. She was interrogated by the police. She was never told at any time by the police that she was free to leave. So the case finally went to trial, the defense, Mr. Scheer, who represented Ms. Trivett at trial, filed a motion to suppress that statement. And he claimed there that the police should have Mirandized Ms. Trivett under all the circumstances. The trial court held a hearing on the motion pre-trial and ultimately concluded that the motion to suppress would be denied. The court below set forth several factors that it felt were important. Ultimately, 4 questions that it posed and then answered each of them in the negative. We set those forth on page 5 of the brief. But the things the court looked at was she handcuffed or told she was under arrest? The court answered that no. Was she told she was not free to refuse to accompany the police officers to the police station? That is, could she have just said, no, I don't want to go? She answered that in the negative. Was she placed in a marked police cruiser with a cage in it? And the court answered that in the negative. No, she was not. Finally, was she placed in an isolated room, which was the equivalent of a jail cell? And the court answered that no. Well, that's probably true, that all the answers to those questions should be no. But it's our position, Your Honors, that the court really had the wrong focus below. And this is where the court erred in denying this motion to suppress. This, we contend, was a very calculated and orchestrated effort on the part of the police to absolutely convince Ms. Trivett that she had no choice but to go with them to give a statement. They created, through an entire set of circumstances, a scenario in which she absolutely should have reasonably believed, as any person would have under the same circumstances, that they were in custody and had no other choice. Under those circumstances, and the scenario the police created, they should have told her that she was free to leave. They maybe should have advised her that, you do have the right to an attorney. They should have Mirandized her fully under these circumstances. That is our position. It's our position that the procedures employed in this case made an absolute mockery of Miranda and the Fifth Amendment. And that is our position here today. This court has held, and we've cited in our brief, and I think the state has not disputed this, that essentially custody exists, and I put custody in quotes, where the restraint of freedom of movement is to such a degree that it can be equated with a formal arrest. Well, again, looking at all the facts that we recited here, it's very clear that any person would have believed that they were under formal arrest. What the police did in this case was the equivalent of a formal arrest. The only thing they missed was the handcuffs. But we contend that the procedures they used were every bit as restrictive as handcuffs, just a lot more subtle.
Counsel, I'm thinking of some of the circumstances. I understand your argument, and I understand somebody in those circumstances being extremely frightened anytime police are involved with anything, let alone under these circumstances. But nonetheless, as I recall, when we're looking at what occurred here in the facts and circumstances, you say it's equivalent of a formal arrest without the handcuffs. When you formally arrest somebody, you usually don't leave a door open, you don't leave them their cell phone, those type of things, right?
That's true. I'm saying for purposes of whether Miranda should have been administered, it certainly, for maybe other purposes, if you want to equate it to an arrest, it may not. If we're trying a false arrest suit or something like that, I would agree there's distinctions to be made. But for purposes of whether she should have been Mirandized, absolutely, I think beyond question, she should have been Mirandized. And I think it was very clear that the police created a scenario that was designed to skirt around, if you will, the requirements of Miranda. And I think a very telltale fact is that it came out in trial that these in-laws who had tipped off or prompted the Bedford police indicated that all all the officers really needed to do was just pick her up and, quote, stick her somewhere, and she will trip herself up. And that's what they did in this case. They picked her up, they stuck her in the basement of the Medina Police Department, and they interrogated her for 2 hours without the benefit of counsel, without the benefit of Miranda warnings whatsoever.
You said that information came out at trial. Was that part of the hearing on the motion to suppress, that the trial judge knew at the time that the decision to not to suppress the evidence was made?
I believe it did come out from the officers that that is the Medina officers, that this investigation was prompted by contact from Bedford. To answer your very specific question, I would have to honestly check the record to see if that second part of the equation there came out in the hearing or later in trial.
And we'll obviously review the transcript.
Thank you. And I'll see if I can check that very quickly. So it's our position, Your Honors, that to sustain the admission of the statement in this case and to not overrule the trial court's denial of the motion to suppress that statement would in fact make a mockery of Miranda and all it stands for. And we've cited for you in our brief a lot of cases that talk about the factors to consider, and I think that this case hits on many of those factors which we've already cited. Just very briefly, I would like to touch on also, we did raise 2 other issues. One is the sufficiency of the evidence, which actually in the heading of that argument, it says that it's directed towards the weight and sufficiency of the weight of the evidence. It is a sufficiency argument that follows, and that's the issue that's raised. We contend that viewing all the evidence, and even in a light most favorable to the state, that there was no evidence of the required element of recklessness that's needed to support this charge here. So that's issue number 2. And we've set forth all the facts and circumstances in our brief, and unless the court has questions about those, I won't go through those at this time. Thank you.
Thank you.
Thank you, Your Honors. May it please the Court, my name is Matthew Curran on behalf of Dean Holman, the Medina County Prosecutor. I represent the state of Ohio in this matter. I'd like to focus my time, as Mr. Dixon did, on the first assignment of error, the suppression issue. And I think it's important to put some of the facts that he's articulated in some additional context. Might be somewhat important. First of all, the reference that he makes to the testimony about Detective Grusendorf going to the husband's family, the in-laws of the defendant, for lack of a more descriptive term, and something about stick her in a room and she'll trip herself up. That testimony does not occur in the suppression hearing. That testimony, only Detective Gross testified at the suppression hearing, according to my notes. That Detective Grusendorf did not testify until trial. So that information was not known until trial. It was not before the trial court for its determination. Secondly, that information would be entirely irrelevant to the suppression decision. The Supreme Court has specifically held that in determining whether a person is in custody in this sense, the initial step is to ascertain whether, in light of the objective circumstances of the interrogation, Stanbury versus California, a reasonable person would have felt he or she was not at liberty to terminate the interrogation and leave, Thompson versus Keohane. An officer's subjective intent is irrelevant for those purposes. It does not bear on the objective facts known to the person being interviewed. Ms. Trivett had no idea the subjective intent of the detectives when they were conducting their interview. What her in-laws said or didn't say to Detective Grusendorf when he met with them before Ms. Trivett's interview has no bearing on what Ms. Trivett understood in light of the objective facts. For that reason, although I understand Mr. Dixon's attempt to paint that in a negative light, it has no bearing on this court's analysis and its review of the trial court's decision. A, because the trial court didn't know about it at the time, and B, because it's irrelevant under Fifth Amendment jurisprudence. Secondly, I do agree that Custody is generally, for Miranda purposes, determined based on a question whether there is a restraint of the freedom of movement equivalent to a formal arrest. Say versus Rafferty, this court in 2015 said as much, citing a long line of cases. The question, however, as Rafferty and other cases specifically held, depends on context, and there are a number of factors to consider cited in our brief. First, the location of the interview, and there are specific cases holding that the simple fact that a person is taken to the police station does not mean they are in custody for Fifth Amendment purposes. Miranda warnings are not automatically required anytime someone sets foot to a police station. The other facts and circumstances of that location are still required. Second is the duration of the interview. Does it last 6, 7 more hours to the point where a person might not feel free to leave after a certain period of time? What are the actual statements made? Does a person's statements have any indication that, from the context of what they're saying, that they didn't feel like they were free to leave and were only giving answers to try to get out of the place they were being held? Physical restraints. Are they in handcuffs? Are they actually capable of moving from the location where they are being held? And finally, in Rafferty, this court said, the release of the interviewee at the conclusion, that's a factor that bears on the court's determination for a suppression issue. So those 5 factors, let's review. Yes, she was taken to the police station, but she was at her apartment. The police came. They asked her to accompany them to the station, and she agreed. Initially, she said, sure. She said, well, can we do this here? And they said, well, we'd really like to talk you down to the station. We'd prefer that. She said, okay. And she came with. The police, yeah, there's some reference in the transcript to them directing her to put her shoes and a coat on, but okay, but it's not an order. It's not in the context of put your shoes and coat on, you're coming downtown and you're never leaving. It's, oh yeah, come on downtown, grab your shoes, grab your coat. Let's go.
Well, we don't really know that, do we?
Well, in the sense that a transcript does not reveal tone,
Right.
Correct. Which is why this court must, under Burnside, defer to the factual findings made by the trial court. And as long as there's any competent, credible evidence supporting the trial court's decision under Burnside, you are bound to accept those conclusions as true. Your review is a de novo review of the law.
Did the trial court make a factual finding that she requested to drive her own car?
Obviously that testimony occurs. I don't know if the court makes a finding in its entry to that effect, but I don't think there's any dispute that occurred. She did offer to drive her own car, and the police said, no, we'll drive you.
And what would have been the reason for not allowing her to drive her own car? If this is consensual and just come along and we just want to talk to you?
Well, I can think of a number of different possible explanations for why the police would not want someone to drive their own car, especially if, obviously she's been going through a traumatic situation. This is obviously occurring after TT has ingested the Wellbutrin and is still recovering from the admittedly serious ramifications consequences that caused. So that's maybe a reason why you would not want, obviously the police are cognizant of the fact that whenever they show up at a location, people are a little more on edge than they might otherwise be. I think that's fair. And so the police, taking into that account, might say to a person, oh, well, we'd like to talk to you, we'd prefer to do it down at the police station if that's okay with you. Yeah, maybe you driving right now, not a great idea.
But this was a couple weeks after the event.
Sure.
And did they explain why they didn't want it? Was that testimony regarding that?
I don't believe that they told her the explanation.
Of course, an argument could be made, it's just an element of control, because then she can't, they're gonna know she will come down, she's not gonna just say she is gonna take off somewhere. And then number 2, they control really when she can leave, unless she would call somebody to come and get her.
Or unless, there's testimony that the police station was not that far. And she had her cell phone with her, she was capable, it was the middle to end of March. So it's not as if she was really insistent on leaving, that she wanted to exercise that decision. It wasn't like that was not an option. This was not.
Oh, I'm sure, you're always capable of leaving if you're not in handcuffs, but my point is, it's just more, when you're weighing these factors, wouldn't that be a factor that you'd weigh in regard to element of control?
I mean, from an objective standpoint, admittedly, yes, that does tend to suggest that the police very much wanted her to come down to the police station. But again, subjective intent is irrelevant. It's how she understands those facts and circumstances and whether they would, in a reasonable person, convey the sensation, or convey the understanding that she was not free to leave. And at this point, that is not, we're not at that level yet. Asking someone to accompany you and suggesting to them that you'd prefer you drove, by itself is not coercive or suggestive enough to overcome a person's free will.
How about placing her in the back of the unmarked car with the doors locked?
Well, the doors
With
locking.
another officer.
The doors locking is an automatic thing. I mean,
Sure,
most
but
new
they
cars
could,
that happens.
you know, have her sit in the front passenger seat.
And I think Detective Gross testified at the suppression hearing that that is just not procedure for any passenger. There are control issues with a person sitting in the front seat capable of reaching over and, interfering with the operation of the vehicle. Any person who rides in a police car, marked, unmarked, is in the back seat. And, there are two detectives, as Mr. Dixon points out, who are going with Ms. Trivett, and the second detective sits in the back. So the same is actually true for the second detective. That it's not that there are two up front and she's the only person in the back and the doors are locked and she can't get out. There's a second detective in the back seat with her. So to the extent that there's any kind of social interaction that would be conveyed, or any kind of social norm, more, if you will, being conveyed by, I'm in the back of a car with two police detectives, is actually ameliorated by the fact that the other detective is in the back seat with her.
Well, that depends on how you look at it.
Exactly.
Because it could be a matter of another detective is there to keep an eye on you to make sure that they're watching every move.
Fair. The other thing here is when they do get back to the police station, there's reference that they lead her downstairs into the basement for this interview room. The Detective Bureau in Medina is actually, there's testimony, that's where the Detective Bureau in Medina is located, in the basement of this building. There are no series of doors that are locked that she has to go through. She enters through the door, they go down a set of stairs, and they're in the common area where the Detective Bureau is housed. It's not, like a jail facility where you're being led through a series of locked doors that have to be buzzed open, creating a sense of, I'm never getting out of here. It's a basement of an office building. So there's nothing insidious about that. When they do go to the interview room, the door is left open. She has all of her property with her. Her purse isn't taken from her. She has her cell phone. They talk to her for a while. They take her statement. And then when they're done, what do? They drive her home. They don't arrest her. They don't detain her. They don't seize her immediately and say, aha, we've got you. You're never leaving now. No, they honor their original promise. And they told her at the beginning, we'll drive you and we'll take you back. And at the end, that's exactly what they did. The objective facts and circumstances of this case show that she was not in custody for purposes of Miranda. The warnings were not required. There's some issue with these tape factors the defendant cites on brief. I think we've taken some issue with a couple of those factors in our response, specifically whether or not you have to specifically tell somebody that they are free to leave. I think the case law is pretty clear. You do not have to tell somebody they are free to leave in order for that to be weighed in the state's favor. Obviously, if you affirmatively tell someone they are free to leave, that is a bonus from the state's perspective, but you don't have to. That case law is pretty clear. The second factor under Tate asks if the defendant was a suspect at the time of the interview. Yet again, subjective intent is irrelevant for purposes of custody. The objective circumstances control, not the officer's subjective intent. Wren, all those other cases about an officer's subjective intent being irrelevant for purposes control. Tate, to the extent that it contradicts those, is A, an out-of-district decision that is persuasive at best, not controlling, and B, it contradicts U.S. Supreme Court and therefore Ohio Supreme Court precedent interpreting the Fifth Amendment. This court is bound to follow those controlling decisions. The remaining factors all weigh in favor of the state. Her freedom to leave was not restricted. She was not in handcuffs. The door was left open. She was in fact taken home at the end of the interview. She was not physically intimidated. There's no evidence, there's no even suggestion at the suppression hearing or on appeal that she was coerced, that she was physically assaulted in any way. There's no involuntariness aspect here. The simple question is custody. And there's no evidence that a reasonable person in her situation would not have felt free to leave. If she really wanted to leave, she could have asked, hey, I want to go. And they said, okay. She never asked, which to a reasonable observer looking at that situation, asking what a reasonable person in that situation understood, would they feel free to leave? If a person's not even asking if they can leave, if a person is not even, I have all my things, I'm not handcuffed, they gave me a ride and they're taking me back, okay. A reasonable person in that situation would not have felt that they could not leave. They were not restrained.
Or perhaps a reasonable person would not ask because, given all the circumstances surrounding, they would believe that they could not leave.
If that were true, then at the end when they say, okay, we're going to drive you home, there would have been some kind of mild shock, surprise, unexpected showing of emotion that, oh, I get to go home? Oh, I didn't think that was going to happen. Nothing like that happened here. So it's evidence that if you are looking at subjective intent on the part of Ms. Trivett, she didn't believe that she was not free to leave.
Well, it doesn't necessarily mean that you don't think that you're ever going to leave, but for the time that you are there and while they are asking questions, that you are required to remain and to answer those questions. That's the issue.
Okay. The point that I'll make in response to that is at no point during I think it's a 2-hour total lapse of time between when they showed her apartment and when they drive her back to her apartment. At no point does she, at no point is she in custody, and the reason we know that is looking at the factors. She's not taken in handcuffs. She is not told that she's not free to leave. The police tell her why they're there. I mean, it's abundantly clear, hey, we're looking into this, we'd like to talk to you, get your side of the story, what happened? And she says, sure, no problem. I mean, she offers to do the interview in her apartment. So the interview, she's very clearly indicated that she wants to do the interview. It's the location that is apparently now the issue. The fact that it happens in the police station does not by itself render this a custodial situation.
But hasn't Sherry then said no twice? I'd rather do it here. No, you can't. I'd rather drive in my car. No, you can't.
I don't know if that's a no, Your Honor.
Well, she wasn't able to do it there, and she wasn't able to take her own car. So twice they told her, no, you're going to do it our way.
I don't know if it was so much of a, you're going to do it our way, as a, we would prefer not to do it that way. We'd like to do this at the police station. And she agreed. She didn't say, oh, well, then I don't want to do the interview, go away.
Police, and there's 2 of them.
Were they uniformed?
No. These are detectives in, I mean, you could call them Class Bs. I think they have polo shirts and khaki pants that they
That identified themselves.
Yeah, so they identify as police officers, but it's not a full-fledged, police Class A uniform. So it's not suggestive or coercive in that manner.
Counsel, you're.
Thank you very much, Your Honors.
You have 5 minutes.
Thank you very much, Your Honor. First, to clarify, we do agree with the state that second part about the in-laws saying just take her to a place and you can trick her or something like that didn't come out until later in the trial. Your Honors, if I may, the state is correct that this court is bound to accept factual findings of the trial court, at least give them great deference where they are supported by facts. And we don't really dispute the law surrounding that. But the problem here is it's not so much the findings the court did make, it's the ones that it, and I won't use the word ignored, the facts that it ignored, but there's certainly a lot of facts here that the court didn't deal with in any way. And so you could almost accept the 4 factual findings that the court made that we talked about before, but still easily overrule the court for the things it didn't consider. At page 8 of our brief, we cited this court to State versus Bryant. And Bryant sets forth a listing of 10 factors which it indicates the court really should consider whether a situation is custodial for Miranda purposes. First being, what about the location where the questioning took place? Was it in the defendant's home or was it in a police station? Well, in this case, it was in the more restrictive environment of a police station. Was the defendant a suspect at the time the interview began? And the court cautions, bearing in mind that Miranda warnings are not required simply because the investigation has focus. We understand that. But yes, she was a suspect. That's why they were there. They were investigating what they believed to be a crime, and she was eventually charged with it, largely based upon and the statement that was used heavily in trial. Number 3, was the defendant's freedom to leave restricted in any way? Yes, absolutely, in many ways, and this court's discussed a few of them. The perp walk coming out of her house, one officer in front of the other. The locked car as soon as she gets in, the officer next to her. The refusal to let her use her own car. Taken to the basement of the police department, where she then again asks, may I take this form, this statement home and fill it out? The answer was no. Usually when police officers tell me no to something, I understand what they mean. That means no. They did follow that up with saying, no, we prefer you do it here. But again, I think we're, in the context of this, and the young lady in the basement of the police department, she'd just been brought in the car, she understood no to mean, no, you're not going to fill it out anywhere else, you're not going to leave.
Well, you would agree, would you not, that effective police interviewing would involve some give and take, question and answer, not here's a piece of paper, go home and write, what happened.
I agree, absolutely, but I think her question was more, can I leave and take it with me? And to that point, she heard the answer, no. If they had maybe explained, no, we want to be able to have some dialogue with you, that may have been a different answer.
Of course, that dialogue could have taken place at her home.
Yes, absolutely. And again, back to Bryant, did the police verbally dominate the interrogation? Well, there's 2 officers there. She's in the basement of the police department. I think you could easily said, yes, they dominated pretty much the whole situation, the whole scenario that I'd say was created.
Do we have a video of the interrogation? Is that in the record?
That is an excellent question, Your Honor. Yes, I think that, and that does bring up another point. One of the reasons, and I think this gives you some idea of why we say this was a scenario the police created. There was some suggestion that the reason she was taken to the police department was to have this recorded, video recorded. Well, it came out that, in fact, the video equipment wasn't even working there, but they did have a body cam that was functioning when they went to her home. So, truthfully, they could have recorded it better and easier with the body cam than taking her to the police department where they were aware that the system wasn't even working. So that reason that is posited by the police for taking her in just doesn't make any sense whatsoever. And again, Your Honor, I wish I could ask trial counsel, who is present here today, if that was put in the record, and I doubt he would miss that. So,
We'll have the record.
In counsel, you need to summarize.
Thank you, Your Honor. And, Your Honor, for all the reasons cited, and I practiced law for 35 years, criminal law exclusively, and I rarely try to interject my personal opinion in a court of appeals argument, but I found the activity in this case shocking and quite unbelievable, actually. And we ask the court to reverse the trial court vote. Thank you.
Thank you. Thank you. The court will take it under advisement and will issue a written opinion that will be sent to both sides as well as released on our website. Thank you.
Thank you, Your Honor.
And thank you for coming to Akron.
Thank you.